That's all good. Okay, welcome into the workshop. Workshop. We are going to have a change around. We're going to start with the navigation safety instead of the flood control. So we'll pop around. Is that okay, Liz? Are you leading this? No. Okay. Lyndon, who's leading?
Should we be online? Should we be online?
I think we are. Are we all? You can be if you can.
When the council meeting comes to morning.
Oh, we got someone.
It's the same thing.
Yeah. So everybody online. We're all good.
I think so.
Right. Who's
I'll start. Yes.
yeah, go for it.
Yeah, kia ora koutou. We'll rush through what we've throughout, but we've got a wee bit less time, so we'll try and cover the content. But if you've got questions, we can take them at the end and come back to you. I'm not going to talk to you. You're not going to listen to me today. I've got my team who have been working on the bylaws, both navigation safety and flood control and management bylaws. So I'll let them lead this, and we'll do a bit of a team effort, and you'll see people coming in backwards and forwards from the desks to talk you through. We're just going to start with conversation around work.
She's not listening.
We're going to just outline briefly what bylaw making powers are, and I'm just having issues with my how we've got, just give you some context as to what bylaws are, and then we'll kick into navigational safety and then this flood control and management. Okay, we might.
James changed. And next year, you realise that.
What's the best way
Yes.
Morning, everybody. My name is Vicky. I'm in Liz's team in the regional team. I'm just going to take you through where the council's bylaw making powers come from, just as a take it back to the start before we get into each of the bylaws. So the bylaw making powers for the council for the flood control bylaw and the navigation safety bylaw, they have different origins. So section 33M of the Maritime Transport Act is where the council gets the ability to make a bylaw to ensure maritime safety in its region. And the powers to make a bylaw in relation to flood protection and flood control works comes from the Local Government Act. So the steps for making the bylaw for both those bylaws are the same and are prescribed through the Local Government Act. So there are 4 steps. The first being to identify the problem that a bylaw is seeking to address. Next is determining that a bylaw is the most appropriate way to address that problem. From there needs to be a determination that the bylaw is the most appropriate form of bylaw. And the last step is to determine whether that bylaw gives rise to any implications under the New Zealand Bill of Rights. So once we go through those 4 steps set out under the Local Government Act, we can then progress through to the Council's special consultation process, which is what we'll be running both of these bylaws under. I'm going to jump through. That vacancy.
Hello everyone. I probably don't know many of you. I'm Jess. I work in the planning team going with Lyndon. You've probably met Lyndon before. We've been working on the navigation safety bylaw for the past wee while. Today I'll just give you an overview of the process. I'm conscious of the time, so I'll try and skip through that and we can get to those changes to have a discussion about those. So Vicky had mentioned this already. Navigation safety bylaws sit between the Maritime Transport Act and the Local Government Act. So the requirements of the Local Government Act are the same for both. However, with the infringements, they sit under a different section of the Maritime Transport Act. So this is why there's two separate processes that we'll go through. So on the screen there's a diagram of the process that we've undertaken so far and where we currently are. So it starts with the first drafts of both, so the bylaw and the fees. Because the bylaw needs to be made in consultation with the Director of Transport, that's through the Maritime NZ and the Ministry. So they see a first draft, they send it back to us, and from there we review and we create that second draft, and that second draft is what will come back to you with. The draft that was provided to you was a first draft. So where that orange arrow is, that's where we currently are, awaiting the feedback, and of course this workshop feedback from yourselves can inform that second draft as well. So once we've got the finalised drafts, the bylaw will go off to the consultation process under the Local Government Act. However, because the infringement fees and regulations done through the ministry, they go straight to the ministry and don't follow that same process. Why we're reviewing the bylaw, I think Vicky will cover this as well for the flood control bylaw, but the Local Government Act sets out the time frame that it needs to be reviewed by. So the current bylaw was made in 2009, was last reviewed and amended in December 2015. So they need to be reviewed 5 years after they're made or 10 years after their last review. So for the navigation safety bylaw, it needs to be reviewed no later than December 16 of this year. However, there is a 2-year grace period. So while we go through that consultation process, the bylaw will still be in force while we go through that stage of treating everyone. Second reason, which is probably one of the key reasons, would be infringements. So currently the maximum is $200. Some of you may remember after the investigation from an incident in 2022 that these were considered very, very low, and at the time didn't meet the expectations of the community involved. So that's something we've looked to address this round of the review. So key proposed changes, we've made quite a few general amendments, updates, either to correct, make it easier to understand, easier to use, also to modernise the bylaw. So most of the bylaw is actually from 2009 or before. So there was a lot of updating for us to align with more recent bylaws. So you'll see that throughout the document if you're familiar with the previous one. Other than that, all matters that are addressed in the current bylaw are still addressed in the new one, just might be presented in a different way. New provisions, so we have some new provisions relating to the responsibility of a person in charge of the vessel, and that's just to ensure that there's always someone responsible for the operation of the vessel. It also aids in enforcement, so often with infringements, they relate to a single person that's committed an offence. So if you don't have that person identified, it can then be hard to issue an offence against the bylaw. And you'll see that throughout the document, a person in charge is referenced quite a lot, especially when it comes to the enrichment clauses. Safe open water swimming, that reads like it's just Te Anau. So the safe open water swimming refers to anywhere, and that's a provision that would require anyone swimming 200 metres from the shore to tow a safety float or a swim buoy. However, it doesn't apply if they have a support craft with them. And then for swimming at Steamers Beach, so that's another big change that we've made. So we've proposed the introduction of a reserved area at Steamers Beach that would be reserved just for more swimming, passive activities, and would exclude motorised vessels within that zone. Next, the 2 independent forms of communication. That one I don't need to go into in detail. There are some examples in the bylaw that outline when a voice is an appropriate method of communication. So if you're kayaking near the shore, for example, that's one. Removal of the Surprise Bay access lane, and then the review of the speed uplifted areas. That's more recent development. So after some stakeholder consultation, work is still progressing on implementation of any change, and that's some work that Lyndon and his team are doing. A lot of that is considering not only motorised vessels, but all types of recreation that happens on the water, particularly seasonal activities and how any uplift can affect them. And then the last two in yellow I'm going to talk about on their own, unless there's any other comments or thoughts on that list. We can skip to delegations. Yeah.
Surprise Bay.
Like Manapuri. It is when you're coming out of Pearl Harbour. It's the bay way over on the left. It's an old access lane that's been decommissioned for quite some time, and to be honest, it's an unsafe access lane due to the, more often than not, that landing area, the beach area is actually submerged beneath water, and parking vessels in that lane is the only option, which makes it unsafe. But in the whole time that I've been here, I've never seen anybody using that over there. It had been decommissioned.
And the extension of the swimming lane out front of steamers, where's it going to go to and from? Is it going around?
No, so it's 50 metres from the boat ramp, and then so across Semmage Beach, and then 50 metres from the duty at the yacht. Yeah.
Jimmy, just in relation to that, have you considered a similar rule for Slazer's Beach at Lake Manapuri? That already there.
We in response to the councillor's question, that's we were approached some time ago from community at Lake Manapuri about installing a swimming pontoon very similar to Blue Gum Point. But there hasn't been really any discussion about putting anything in there, but it's definitely as part of the consultation period that comes up. It's something we could consider.
Okay.
Community want to.
Good to continue?
Yes.
So the potential delegation to ICC. So this is still in development. So we're working with the team there on this one. You may be aware that there are access charges at the boat ramp. ICC own the boat ramp and they collect the charges. It has been identified that a need for a mechanism for enforcement of non-payment of those fees may be needed. So they approached us looking for us to consult on their option under the bylaw. So essentially we would consult on a potential delegation to Invercargill City Council to resource the enforcement of non-payment of fees. And that's important, it would only be for the non-payment of fees. So the bylaw, that the role of the Harbour Master will all still apply, it's just for that non-payment in the case that happens. Like I said, it's still in development, so the details are
When you register and they tell you the infringement fines you're going to have, they're not being followed up on. Is that what you're saying?
No, so this is fees and charges for ICC and the use of their boat ramp and APA. So our infringements are different.
Okay.
Yeah.
Registering to use boat ramp.
Oh, okay. Yeah.
Yeah. Because when you register it, we'll talk you through the whole thing. Like as if the whole thing's in place already.
Yes. Yes.
This is it.
Yeah.
We do have ITC representatives.
Yeah.
Yep. Yes.
Casey Wilson from the City Council. Just kind of the team that set up the project. And what would you like to know?
Oh, look, I support the whole, that's brilliant having that whole automated system down there, buying a subscription, but am I picking up correctly that those that aren't paying to use the boat ramp are not being followed up on for their payment currently, or are there systems in place?
So currently within our own policy system, there's an education period before we can enforce, and so we're just currently working through an education period of people being aware that there are fees that are being reduced enough to the fees that they're paying for. So, yeah, so it's just that the education period, nothing's potentially going to
Okay.
put it through a bylaw because it's that.
You're right.
Let's just be councillor Pemberton.
Moving. Thank you.
My point.
Yeah, so I mean, there's a question on the screen there. Any thoughts on us consulting on that with ICC during the review?
What's everybody's thoughts? I think would be pretty supportive with that, unless there's anything serious. Yes. We'll say a yes for that.
Great. View of the infringement fees. And I'm conscious you haven't seen the proposed fees because they weren't attached in the report, but I do have some fees that I can hand around if you are interested. So as I said before, the fees are set under a different section of the Act, and that section restricts self-subscribing a fee that exceeds $1,000. So the current maximum fee that we could set is $1,000. The current bylaw uses a flat fee of $200. There are a couple that are $100. So there is room for us to move. The options the options that we had were status quo, so not changing a thing, which wouldn't address that issue I discussed before. We could have proposed a flat fee, a higher fee, but that didn't take into account, not all offences are the same, so that one may have a worse outcome than the other. So instead, we proposed this risk assessment approach to setting the fees. So they're proportionate to the risk and the consequence of any offence. So this was done by Lyndon's team and a member of the compliance enforcement team. So each of the offences were ranked using the ES risk assessment matrix. So in this context, if an offence was to occur, the impact is the risk of that would occur. So would it be a near miss all the way to injury? And the likelihood is how likely would the risk occur. Likelihood in this case isn't the likelihood of an offence happening in general. So that's important to note. So a rating was given to every offence, and that helped narrow down the range of where that offence could be placed along that scale. And essentially, it was the increased risk was the higher fee. You can hand some around if you'd like to see, although there are about 70, so you're welcome to take the documents away with you. But yeah, any thoughts on that approach and just hand it around?
Could we overlay it?
Hang on. Oh. Here it is.
Yeah, look, I agree with that variance in terms of what the fine is. My question would be, how often have we had to make a fine assessment? Because to me, unless this is very clearly determined, it's an opportunity for litigation, which is messy. And who makes that, what training they have, and all of those sorts of questions surrounding it.
Yeah, in terms of setting the fee, like.
Yeah, well, determining the level of risk, which then sets the fee in motion.
I see. Yeah, so I would maybe let Lyndon answer that. That was
So we looked at each individual offence and based it on how often does this particular offence occur, and also if this particular offence, when it does occur, what is the likelihood? What is the worst possible scenario that we could expect to be the outcome from that offence? So not every fence that we have graded and made in those rules is actually very, it's always a possibility. So we need to be positioned to be able to provide a regulatory action in regards to how we approach that particular offence.
Else?
Then I sort of understand what you're saying, but for simple people like myself, if I end up with a 6, I'm going to get pinged for $700 to $950, $700 to $950. How do you define that point? How do I get to a 6?
How do you get to a 6? Using the matrix there, or just
No, or just, do I cut in front of another boat, or what do I do?
Well, as Jess mentioned, it's not a one size fits all. It's hard to base it on what's the most likely outcome from that particular offence.
Can I just, sorry, you've got the 6s, you've got all the 6s here.
Yeah, no, I can see that.
And the reasons why they have, that's all.
Yeah, but litigation's going to have a go at you if you can't define it, isn't it?
And this is part of the process that this will have a legal lens cast over it.
Okay.
Some of the things I've probably said should be more than 1,000 more. I mean, you're restricted to it, isn't it? Because even where you say, well, I was looking at one of the first ones here, I think to carry sufficient flotation device for each person. You've got to put a 7. You think it's pretty critical to be out there with the right.
Yeah, first and foremost, it's going to be education. This is a tool that we can use if we absolutely necessarily have to, and there's a risk of injury or fatality as a result, but for those lower offences like that, and a lot of these have been based on other regions and what they have done, so we're trying to get a regional consistency.
Yeah, I've got about 4 questions actually. Paul, John.
I know the consequence, impact, or risk of carrying near mass injury, fatality. What about repeat offender?
Absolutely.
That's part of that filter that we should put in, because a lot of times you find it is the same person again. You're going back every time.
I don't think the infringement offences actually allow for that.
No, it would be good though, wouldn't it?
Oh, absolutely. And repeat offenders, you would expect if it's a low level offence, if it's first time, you're looking at warning, and then after that, repeat occurrences after that, you're looking for another tool to use.
Right. I didn't notice, not following the right hand rule. $500 things. You just sit at the entrance of the boat harbour and wants to not follow that rule.
And that one we've had a lot of issues on the upper way out with boats versus recreational vessels. Commercial versus recreational. Some people know the rules and some people
don't. Just carrying on from that, I do remember there were stickers that were handed out with the boat, the arrow, giving indication quite easily, and you put it right in front of the driver. And do we still do that?
And it's funny you should mention that. Only this morning that the team are working through all our brochures for the coming summer season, and we put out boxes of those. And said, look, these will be going out.
Slap them on the dash. Yeah, no, good one.
John.
This is quite encouraging to see. I think safety on our waterways in Southland we've got away with a lot, I believe. We can see that. Question: is there anything in here that is obviously speed zones will be different in every region, but is there anything in here that is specific just to us in Southland that boaties won't be aware of?
Quite possibly Milford Sound, and that's more for the commercial operators in there, where instead of up to 200 metres, it's the speed limit at 100 metres. Speed uplift areas, but of course all that information is,
Yeah,
it's relevant and it's obtainable via South Maps now.
so just reading here about life jackets on recreational vehicles, recreational craft, is it referring to vehicles or vessels of a certain size?
All vessels,
So the 6.5 metre rule,
vessels 6 metres and under is compulsory.
yes.
Right, Lyndall, Roger.
Thank you. Just wondering about your rationale for having bottom right corner, particularly a rear event, catastrophic column reading of 5. Just
Yeah.
because a catastrophic outcome maybe is more than $500.
Yeah, so we were, in this case, restricted to the ESV matrix, so we didn't make any changes to that boxes.
Right. Can we? Can we? As I say, I would have just thought that it doesn't matter how rare it is if the outcome is catastrophic. $500 to $700 fine is not sufficient for me, I would have thought. Yes, yeah.
I think I'm going to be in the moment.
No.
Roger.
Yep,
Yes, yes.
yep, I certainly agree with that, catastrophic, even major outcomes should potentially have higher infringements attached. I guess the benefit of the matrix is transparent as to how the fees are transferred across. But the comment I was going to make was regarding the list here of descriptions of offences, and A, it strikes me as quite long. B, I wonder if there's some opportunity to consolidate some of there are some incredibly specific offences in here, such as failing to keep jet boat noise to a reasonable level on 2 specific rivers. So I just wonder whether that degree of specificity is helpful in this context, or whether it would be, for both enforcement and the public's interpretability, better to have some more general kind of offences that are easily understood and not as place specific or activity specific.
Yeah, so what's in that list there, it is quite detailed, and that's due to what the ministry was after from us. When they draft their regulations, it needs to be really clear what laws that we're referring to, which is why it's the softest word for word from the bylaw to help them draft them. But I do know if you're saying it is.
With that in mind, what would reasonable noise be on? How would that be enforced?
It is in the code of practice, and I can't remember what it is. Yeah, we can have a look and get back to you.
We are prepared, yes, ma'am.
And that's, to be honest, it has been a concern of mine as well, so having measured it.
Might move on, but you're gonna.
Congratulations, guys. Obviously, from a regulatory point of view or an enforcement point of view, you need to be quite specific. I understand that. Linking that back to the maps though, so we do quite a bit of boating in Fraser's Beach, up the beach. So I suppose my point would be that this needs to be communicated. If it's brought into by law, it needs to be quite well communicated with our community, because based on what I see in the map, we haven't been adhering to what we're supposed to be doing. So, the community need to be made well aware. The new bylaws. I'll learn pretty quickly. Oh yeah, but that's what I'm saying.
I've just got one question, Lennon, in regards to this. Obviously, you're comfortable with this yes/no question. You're pretty happy with this sort of structure and the way that, and you're asking, do you support this approach? You're pretty comfortable with. You're the ones policing this.
Yeah.
Yes.
This is clear and precise for you to be able to police this, and that's what you want. That's what I want to hear. Jeff, and then we'll carry on.
Going on from what Jeff was did your essentially you've got that blue piece and first features of ski lane. So would you not have a couple of lines up there that delineated the ski lane?
Those have been sometimes they're over there, right, and there's markers out 100 metres.
Good idea.
So we've got do we support the approach to setting the improvement fees?
I would support that.
And we're all comfortable with that?
Yep.
Yes.
Yep.
Only taking into account this.
The approach is fine. It's
No, that's all good. So happy? Yes.
That's all we have, slides, if you have any other questions that we can cover. Bring it down.
Just a question on how it's set up down in the bluff. Do we see potential of that, obviously resourcing all of this? Obviously, yeah, just about just resourcing all of this in general. How do you see going forward with boat ramps, the management of that, and is the ICC model down the bluff one we need to be looking at, especially in like Fjord and really, I guess it's ownership issues in Fjord with that boat ramp, but there's certainly a lot of use and I think people would rather invest to ensure that in the future doing that than that sort of pulling away and falling apart.
Well, the one good thing is that ES doesn't own any boat ramps.
Yeah.
But the model that ICC down there, I think it's great, and self-funding. It's a good model, and it's what most of the other regions are doing at the moment. Really beneficial. You look, for example, Colic Bay, the boat ramp here, have struggled over the years to actually keep up with funding, and various boat clubs that had ownership of it have come and gone, and they've suffered as a result because there's no funding mechanism. It's great.
Just can you remind me what there was a fine that was pretty minor. I can't remember what it was in the paper, wasn't it?
Yeah.
And we had to
Yes, $200.
$200 for what, wasn't it?
It was for collision prevention where the skipper wasn't paying attention where he's going and he collided with the skiff. And the occupants of the skiff received varying sort of levels of concussion, but one young girl, she lost about 3 teeth. And the end of the war smacked her on the face.
$200 fine. That what I was needing to hear. No, that's good. So that's you. Oh, sorry, Roger. Any more?
One more, sorry.
questions?
Just picking up on the boat ramps, and the Bluff boat ramp has become a really popular location for locals to swim. You know, there's dozens, if not, of kids down there swimming. What situations does put them in?
ICC also going through the process of developing a swimming area and a pontoon which has been discussed with the community. So as part of that, we see that normally the bylaws restrict people swimming near boat ramps, etc. And that's at all times. And I think a bit of a pragmatic solution can be found, and it's modelling on the other regions, is that yes, no swimming there, but only when there's actually a vessel there that's being trailered or untrailed. The rest of the time, swim in that particular area, but just need to exercise caution. And that's the approach we'll be looking at to support that safe swimming area as well. So it means just tweaking the bylaws just slightly to be able to accommodate it.
No, all good. Any other questions? Move on to the next. Thank you very much. Very good.
I'd like to say just one last thing, that commend Jess and Liz's team. They've done an amazing job on the bylaws to get it to where we are at the moment compared to what it was. So it's credit.
Well done. Right. David, we see
We'll tag team.
tag team.
We'll tag team. So I'll just quickly just give you context around where this is sitting, where it's come from, and then we'll hook into some detail. So as we've already talked a bit about today, there's obviously kind of a multi-pronged approach to how we're going to improve the state of our infrastructure following the last LPP, additional resources provided, which has been very helpful and well received. The bylaw is part of a broader range of that work. The change was initiated at the end of last calendar year. There was a number of work that was held both with the previous council and with the catchment liaison committees to seek initial feedback about what was broken and what needed sorting and how we might address some of those things. Also underway, just setting the context. So we've also got the asset management improvement plan that was referenced in the council meeting earlier, an asset management policy coming. We've got reinstatement guidelines that team have been working on for our banks. We've got code of practice review for Rule 78, which is coming out of that Rule 78 appeal, something separate again. So today, primarily, we're just focused on updating you on where we've gotten to with the bylaw as it currently is, and seeking some further thoughts from you. So it's probably enough context unless you'd like to add anything to it. So the purpose of the bylaw is principally to protect our assets. We obviously have a wide range of assets, about 500 kilometres of flood banks. We've got tidegate pump stations, drainage schemes, bridges, culverts. Drainage schemes are in addition to that 516k. We've got a few bridges, few culverts and a few detention dams. Our work programme primarily carried out by the river operations part of my team. We conduct annual inspections and maintenance, obviously, upgrades as we go through the year.
Quick question, we own 500?
560.
How many private flood banks? Because there are banks where it stops and at some stage someone's decided that don't own that.
And even the parts that we do own, we don't own the land that it's sitting on necessarily.
Okay. But we
so I
maintain-
don't have the number of what like kilometres of private there would be, but I can find out from Steph. It'd be in the spreadsheet.
They were all put in at the same time, but at some stage in the past they
And
stopped ownership and
part of that
some people
broader
didn't know
range,
that.
broader range of work that we've talked about. So one of the things that the reinstatement guidelines and how we do our inspections, so we're looking at how we do those and how we can get a bit more efficient and effective, back to our conversations from before about the defects. And one of the things that the team have been flagging is how we work through in a systematic way with landowners, so that we're starting to build landowner agreements with those landowners who have our banks on their land. Those don't exist consistently across the region, so in some places they're there and in some places they're not. So we'll be working through that as part of the broader range of work that's underway, not specifically in relation to the bylaw, but the bylaw obviously puts an onus on the landowners to do a bunch of things. So some of the reasons for why a review of the bylaw is needed. Managing emerging issues that are impacting or have the potential to impact the integrity of our assets. So just some examples of where things have been counter to what we would hope have occurred and have caused us problems. There was a raft of other pieces of feedback about lack of clarity about fencing, stock fencing being in the wrong place, not in the ideal place when it comes to actually preserving the integrity of our assets. So we had quite a lot of feedback late last year, through the year last year, about how the bylaw wasn't kind of fit for purpose in its current state. So that was another reason that triggered us to have a look at it. Jumping in any things. So some photos here in terms of that broader kind of floodway damage and some of the impacts that we see where people are doing things, not necessarily, and as you were just talking about with the navigation, a lot of places people don't know what the bylaw tells them to do, and when we do our inspections and we walk the banks and then we send them a letter and tell them that they've done anything they shouldn't have done in relation to the bylaw, quite often we get a response of, I didn't know that was a thing upon us. So I think that broader kind of how we get landowner understanding and agreement is a really crucial part of the next step. But needless to say, we have a fair amount of evidence of our floodways being not ideally used for the purpose for which they're intended. So we have from the work I was doing before, I tend not to really like to have fixed things like maps in plans and bylaws, because then they become static, and that isn't the nature of our business. So by putting a map in the bylaw, it does restrict our ability to keep it fluid and keep it updated. There was a number of other issues with it in terms of the climate change gap and our values from Tagata Whenua. We needed to review it. The last time it was reviewed was a fairly light touch one. This is a bit more expensive, and it requires a review no later than May of 2027. So following all of the feedback that we received last year, and through the AGMs and through the workshops that we conducted with the previous council, the key proposed changes, amending definitions, a new one, adding some more clarity around how we can manage stock on our banks, and then exempting us from the bylaw approval process when we're undertaking work. So getting really clear about the fact that it's a provision not for us, it's for other people, and we'll be capturing our work through some of those other things that I mentioned, code of practice review, etc. Moving the maps so that they're online, which means that we can amend them as we need to through and after flood events, or if we're doing upgrades, etc. And so that'll be enabled by the asset management system that we have that sits in the background of all of our work planning. And as I said before, that clearer provision on what the responsibilities actually are for owners and occupiers, and what steps there are for council to take. We've got an implementation plan in draft that's been pulled together by a cross-organisational group, and Simon, who's not here now, but Simon Stokes, who's the new land sustainability manager, has been helping kind of pull that all together. Really critical part of what we're hoping to build in an integrated approach is that it shouldn't be solely on my team to deliver these kinds of messages and to support our landowners and our communities to understand what their responsibilities are. From my perspective, our perspective, the bylaw should be just catching, those who are repeat offenders, for lack of a better word, as opposed to everybody getting a letter every year when they don't know it's coming. So we really want to make sure we're combining the consultation on the proposed changes to the bylaw with education piece and an awareness piece, so that people know that they do have some responsibilities and what those are, and then that we help them to rectify where they can, and where they don't, then you've got a route by which you can take enforcement action.
All I would add is you've had a bylaw for quite a few decades, and so we are building on the existing bylaw and making these key changes. They aren't major changes, they are. The biggest change really is around the winter grazing, and as you saw some of the photos that Lucy put up before, there are some quite significant issues out there, but the rest of it is very much standard from your old bylaw. Recognising last time you went out, there were 5 submissions on your last bylaw when you went out in 2020. I don't know what happened in 2010 because we had it for 10 years last bylaw, but again, it's really a rollover and a tidying up of a few things that we feel are appropriate at this time. And the major one would be just that winter control of stock on our floodbanks.
Sorry, I've just got one question before David. The 2021 was one we had to deal with. I think it was all the bales, and just to remind me, trying to get the bales out of the floodplains.
Yeah.
To clarify that.
Yeah, it was right the last meeting.
Yeah, so the 2020 version of the bylaw that was notified in 2019, and so we had the submission period, and then we had the hearing for that not long after the February 2020 flood. So what might have had some opposition as far as managing the storage of baleage on the floodplain, etc. It was a hot topic because there were 1,200 bales ended up in the Lower Mataura. Councillor McCallum had baleage from his neighbour's farm come down and through and take out all his fences and things. So and then you had examples like that, shipping container wrapped around a tree.
No, but David,
Yeah, look, I've got some concern for this. I understand absolutely the bailage going downstream, that's crazy. But now you've got things on the landward side and 7.5 metres back. And at all times to do anything, you've got to come to council. I actually wonder if that's really what you're after. And then, because it seems like more bureaucracy. And I also wonder, some of the language use, you haven't actually used the words hugging or anything that's, I guess people will know exactly what you want. The language doesn't relate that to farming. And then another part here, you've got you've got to have stock excluded from flood control works for a period of 12 months after repairs have been completed for a lesser period approved by council. So I remember I had a culvert replaced, fencing around it, regrassed it, 12 months. Few months of good going grass, particularly on the landward side. I wonder what the emphasis is. I understand if you've got trees on the landward side, their roots grow into the bank. I understand that, but other stuff, I don't understand why you're so worried about stuff that's near a flood bank, because in every instance they've got to come and seek approval.
There's two things here. One, 7.5 is pretty much a New Zealand standard, and it's so that we can get and control access. Not only, we may want to run machinery up there, we might want to redo the bank, so it gives us the ability to, it's not prohibiting people, it just means you've got to get an authority to do things within that space. And so that's really what we are saying. You can do whatever you like outside. Basically, with inside, there's a whole pile of other restrictions, obviously, but the landward. So it gives us that ability to just control, certainly from a trees point of view, and we've just removed a good partnership actually with ITC, with FCC actually, not ICC, removed a whole pile of trees at Otau, which I think you've seen, but again, they influence when they fall over and what they can do to our infrastructure. So this is just all this bylaw saying, if you want to do something in there, please let us know and we will give you a permit. I am issuing, authorities are pretty quick. They come through, they get assessed by our technical team. They come up for me to sign. We do quite a few of them, but it just enables us to keep control of that. Regarding the language, we've obviously had the law people look over it, but we intend, once the bylaw's passed, to actually, and we've got already a whole pile of flyers that go out and turn the bylaw into common English. And we've got we've got a collective team with the communications team about how we will get this information out so that people, the bylaw is a thing we really hopefully never have to get out of the back shelf. We want people, the education side of it. And so you will get that common English put into that information that will go further on. With the grassing, again, depending on when we do the work, if I build a new stock bank and I might, 12 months gives us plenty of time to get that grass. You can get permission to get on it early if we get it early. So again, seems to be standard practice around there that we've got a major thing and it might take us a period to reinstate it. So it's the worst case scenario, but if you get, if you're doing it the right season, David, and you're doing it in August, September, and basically it's regrassed by December, there'd be no issues of saying, go for it. But basically it enables us to do some quite extensive work, and it might take us 12 months to get it into the condition that we're happy to stop the contract.
True that, I understand, but yes, we're undertaken for a period of 12 months after, so you've got to exclude all stock from the area where the workers are undertaken.
You could get an authority if you want to do it.
I'm not sure that it's really helpful that we sort of run and get a whole lot more authority to do. For instance, if you're brake feeding your stock and there's one of your brakes that's bank. It's about the outcome that you're worried about. And on the landward side, I'm not talking about the other side, but even on the other side, that you briefly go past. And so to come and have to get approval at every stage.
Through you, Chair, just note, I mean, in terms of how we do the process, it wouldn't necessarily be separate authorities. If you were having to undertake work on our banks or on our floodways, you'd be needing to get authority in order to do that. And so part of the authority was the time of year is such that you think you have it regraded in 3 months or 6 months, then that would be part of one authority, not necessarily have to be the separate authorities. So at the moment, as David said, we're getting a lot of these applications. The authorities within the bylaw come through pretty regularly through the River Ops team. So there's a pretty well-oiled machine in terms of the processing of them. We just want to make it easier to understand for the majority, so that we're having to do less enforcement and less letter writing in the front end.
I just wanted for Roger, got a question. These are new points in the bylaw, or is the 7.5 team now?
The 7.5 has always been there. That's carried over from your last two bylaws. I think it was in the 2010 as well. And the grazing, I believe, been carried over. We haven't really changed it. The only one is the biggest change is the 1 May to, what was it, 1 May to 1 June to 1 September.
Yeah. We discussed it about the winter grazing rules, how we just use the winter grazing rules.
Really
They don't
newest
stop on
provision
that.
that come in here.
Yeah, so it's just what they were saying. Break fencing or grazing them, or we can't, not allowed to graze those areas. We don't want it.
One thing we did look at, and is, you know, is there a difference in permanent fencing and in break fencing? Because and I've looked up and down all the other bylaws, and they don't differentiate. The real problem is you can also do quite a bit of damage with break fencing as well. So we've just again kept the bylaw exactly as it was in that provision, but it also aligns with every other bylaw up and down that we've found from the regional councils up and down the country.
Another question about the project.
Well, as you sort of addressed part of the first part of my question, which was around how much use we're seeing of it, how many applications and how that process goes. You might be able to give us more details subsequently on the specific numbers and locations and that kind of stuff. But I guess the other point I was going to make was when we think about how much these things cost to build, they become a really important piece of regional infrastructure, and it's important that we have mechanisms to protect them in place, not just insurance, but this sort of stuff provides us a protection of that regionally significant infrastructure, and that's really critical that we have a mechanism to protect.
I think as well, through you, Chair, I'd just add one of the benefits of doing what we're proposing to do, less on the bylaw and more on how we implement it and talk to people about it, is to increase the wider awareness of infrastructure and why it's important and how people can take ownership of it and protect it as well. I think a lot of what the inspection has shown us is people get unintentionally causing damage to a thing that is regionally significant infrastructure. They wouldn't do it intentionally, it's not malintent. And I think we just need to be a bit more front-footed and helpful about what the requirements are so that they know. And then, the bylaw should be, in theory, lesser used. You shouldn't need to be using it if people understand the value of it.
I'm just kind of connected to some of these comments. I was just going to ask if once complete, does a bylaw update like this, does it provide additional evidence and support of insurance efforts? Do we provide it as a copy of this updated bylaw to our insurance companies to demonstrate that we're taking protection of the assets seriously?
Yes, so through you, Chair, there'd be a couple of the pieces that are currently we've been working on, the reinstatement guidelines, the asset management policy, and the bylaw and the code of practice review will all be being shared as part of that broader suite of this is how we're taking care of it.
Also, one of the questions got raised by Pinar about how do we ensure we protect their investment, because obviously they've got a interest in making sure that they don't put something in then 3 years down the track it's disappeared. just coming back to authorities, Roger, basically, probably most of the authorities I'm giving out are people building bridges or structures and, sort of, so they can cross creeks and things like that, and gravel. Basically, people like McGregor's coming and wanting to take gravel, and because they're working within the floodplain, it's covered by this bylaw, and those are the authorities. There would be very few authorities, I think I'll probably give, would be 10 that I would have given out about vegetation and stuff like that. And over the 6 months or 8 months that I've been dealing with them, not saying that there's, that's typical, but it's just what I've seen.
Just a point when I was just thinking about the fencing and our description of fencing now. Do we have virtual fencing in that description?
Okay, it's an interesting one, because I was
Thinking
thinking about that too.
Yeah, but it is something that needs, even other plane, everything in regards to.
So they come along and they then walk, that's where we get potentially the damage, at that boundary. And Hulk is an interesting one that when you find the solution, Mr. Chairman, could you please?
Hulk works, I can tell you that.
Yeah,
He's got his goals. Yeah, Don, sorry.
Yeah, just on that, in the UK and Europe, they're using virtual fencing for managing biodiversity and floodplain management. So the answer's there, it's just how do you construct it?
Yeah.
It was very interesting at the Wildings conference that they held just recently in they talked about using the collars for control of wildings, and apparently some of the trials have done have been quite effective. So, yeah.
Control tree.
Yes, Chairman, I'm just referring to 6.6 there. You need to be style of teaching it's not about the fencing, rather it's more about keeping stock off. So if you use virtual fencing, I would say that's the equivalent of any type of other fencing.
All good. David.
Yeah, I was just going to ask you the situation outside of the June to September period. Because I've had this discussion and we've had it before. So not all stoppings are the same. So some of them are quite low and rounded, and others have been built with carry-ons and high necks and are very steep and pointed. And so I would like to think that somewhere in here, we might have to go back through, you would have some very good descriptions of what you don't want, so the bugging and the damage and the reasons why. And before you get to, because I would hate to think that farmers would see 1st of June, 1st of September, you're not there, but maybe middle of September you're fine, and it may not be fine, and the outcome could be really bad. On some sections of stoppings, it would absolutely trash, but it'd be sort of okay by this. So that's the difficulty with trying to, but you're going to have to bring.
I think
are you intending to do that, I guess?
Overriding that, they can't do anything that will damage us, so they've got to make some professional decisions themselves. So there's an overriding arch that they can't do damage to our infrastructure. And so, look, in the middle of summer, we could get a downpour that would actually do it. And so, what we are relying on is the professionalism of the people that are running that property. But we will have to make it very clear in our thing that we really are saying we believe that area, none of it's going to be good for you to graze on top of our stock bank. So we're going to say no. In the rest of it, you're still going to have to comply with the rest of the bylaw. And so, you won't be able to put a mob of beef cattle on our stock banks, after heavy rain. There's got to be some professional decisions made in the field.
No, I could drag this on. I know David's got some concerns here, but the reality, I know we've talked about protecting our infrastructure, absolutely, and we've seen some seriously bad situations with livestock on. There's plenty of photos out there. So and it's one of the old things, it's probably easy to say, just don't go there. Make it very clear, we don't want if you damage it, you'll pay for it. You know, we've got to be pretty strong because it's worth a huge amount of money to us. But I understand having a few ewes and things and makes it graze quite nice. And, you know, I'm just trying to, but we've got to have very clear rules, I think, in any of this, that it's not, there's no grey area. I think that's what we talked about when we were dealing with this situation.
And I think of just when I was making before about the breadth of work that's going on, that's not just the bylaw. The bylaw should be like we use our other rules, right? You don't want to have to enforce them. And as part of the reorganisation that we went through in May, the shift of how we enforce the bylaw is now with the compliance team. So we want to get to a point where the bylaw is in really good nick. We've done a whole bunch of education and communication, and we're doing the complementary work, boots on the ground, both my team and also Sam's team, to make sure that people understand what they've got on their property and how we can help, and where the fences should go or can go, and how do we just work together so that they've got that understanding. But it's not all in the bylaw. The bylaw is just the kind of advert at the bottom of the hill, as opposed to, don't want it too heavy, but it's really got to get, as you say, real clarity about the bare minimum that is required.
The correct grazing regime will improve the quality of our stock banks. We want a nice but short sward of grass basically over our stock banks. You know, we don't actually want the grass that's, because basically it hides things, it does. So look, it is a partnership with the landowner that we're doing. But there's just this bylaw, as Lucy says, is, you know, for that 1%, 2% person that might need a little step.
Roger.
It's really helpful to be able to describe that outcome you're trying to achieve quite clearly there. Thank you. And I'm wondering whether we've explored some other avenues for protecting that stuff. The bylaw is one avenue, but are there some other mechanisms that could be used in that private landscape, like covenants, for example, registered on the titles if they're on private? You know, have we explored those other mechanisms that could be used to achieve the outcome that you described?
We've got some strong powers under the legislation there is, and we don't need to actually put another level of there. Ideally, we'd like to own the land underneath it, would be ideal, but we're saying that would cost you 50 to 100 million if you want to buy all the land underneath the stock banks. And you've got the power to do it under legislation. But I do think, you know, through education, through partnership is the way to actually describe the outcomes we want to do. And so that's going to be part of the implementation program that we've, as Lucy said, got this cross departmental group going to how do we get people out there. We want to encourage the right behaviour and not use the stick for the bad behaviour.
And as part of Vicky's introduction, she mentioned that there's certain tests you have to go through before you do a bylaw, and one of those is making sure that it's the most efficient, appropriate, effective. And it is for this purpose, but it's not, doesn't take away from all of those other broader complementary pieces that we also need to create. So the test, we undertook that earlier in the process to make sure that we are still on track to be using the bylaw for what we're using it for. And so that's how we've been able to get to this point.
Any other questions? And David, are you?
Oh, well,
Yes,
I've still got some concerns around flexibility and around the weight of stock, and that absolutely you want short sword, and that people can manage that with lighter animals like sheep. But if you get to a point where you're not able to put sheep on those as part of a rotation for a day to keep the grass short, because actually the grey stuff is the best, they should say, it keeps it nice and short. You're just going to have to work with people practically around that, and the weight of animals is something that needs to be considered in the management, really.
And again, you know, we put up bad examples in the photos here. I could have given you some good examples as well. I possibly should have. You know, a lot of our stock banks are good, but I must admit there's a few that the team's just recently mowed, and if we could afford to mow them all. But yeah, basically it's just, you know, give them the third mow and we can see a lot more. We get a far better indication of what our assets are like and how important that they are and things like that. So, but there are, you know, there are very good examples out there as well as bad examples.
And if I could suggest the wording judicious grazing by the appropriate animals, that really sums it up.
And what you're really saying is give the farmer some credibility that he is intelligent, but prescriptive management is really dangerous. Like I think with the winter grazing thing, you're not meant to go into your paddocks until the end of September. Well, most of them had all been worked up in northern Southland by then. And the ground was good. Prescriptive management is difficult.
Okay, you're happy about telling us where it's going. A couple of thoughts.
We are trying to get it in place for the next winter, so that's why we're intending to bring it to your December meeting.
Thank you.
Okay.
Yeah, for both of them, we're hoping that both bylaws will be really, will integrate some of the feedback we've got today and give reports to you at your next council meeting, which is 10th of December. And if you then make a decision that yes, this is the most appropriate tool this is an appropriate tool to do what we need to do, and give us the okay to go ahead and consult, then we'll do that. From there, we believe that the navigation safety one it's probably a good time to do it over summer. People are out on their boats, they're engaging with that environment. So we're looking to, if we do get the go ahead to do consultation over the summer period. The flood control management, just starting that one in the middle of January, just because we're probably not going to get a lot of people's attention on the farms over that period. But to do that, both sort of ending around field days, so give us a chance to talk to people at field days and have conversations. So ending the consultation by then. But as David said, we're really keen to get at least the flood control one ready and in place so that we can start the communications and people actually know before the winter. But alongside it, yeah, we're going to work with content to make sure that we've got messaging for both, so that people have got awareness around why and what we're doing. So that's really the plan. But yeah, and as Lucy said, Simon and the team across the organisations working on implementation plans for both, so that we know once they're there, we're off and running. Conversation.
Looks good.
Just also recognise Vicky, who's held the pen for us and done quite a good job for us. So you kind of sits in. You need someone on the background to do all the work. So thank you, Vicky. Appreciate it.
Right, that's us. Very good. Thank you for the day. We got there. Early. Wait a bit.
Getting to 2 o'clock in the farm.
2 o'clock in the
2 o'clock was an announcement.
I don't know, that's what, you can see Rob pacing around.